Imagine holding a pristine, legally binding deed to a property, only to discover the law quietly erased your ownership without a single signature. In Jamaica, the Registration of Titles Act governs the Torrens system. Its core promise is simple. If your name is on the register, your title is indefeasible. It is an absolute, state-backed guarantee of ownership. But that guarantee can be superseded by another statute, the Limitation of Actions Act, which sanctions the acquisition of land through adverse possession. Under Sections 3 and 30 of the Limitation of Actions Act, if a squatter maintains continuous, hostile possession of a property for 12 years, the original fee simple title is permanently extinguished. This forces a direct collision between two competing legal concepts, a system that guarantees paper ownership and a law that rewards physical occupation. For real estate practitioners, this means a properly registered title can be rendered void if a squatter has already perfected a claim on the ground. To see how courts navigate this collision, we have to look at Lot 1085, Portobello Heights in St. James, Jamaica. This piece of land became the battleground between two competing claims: Thaddeus Miller, the newly registered paper owner, and Lloyd Robinson, a squatter claiming he purchased the land decades earlier. Their dispute escalated to the Jamaican Court of Appeal in 2025 in the case of Robinson versus Miller. The court had to resolve a conflict between Miller's registered Torrens title and Robinson's assertion of uninterrupted physical possession dating back 24 years. The appellate court's analysis in this ruling provides the specific criteria used to test the limits of the Torrens system against the threat of adverse possession. In 2018, Thaddeus Miller purchased Lot 1085. She acted as a bona fide purchaser, secured a mortgage through the National Housing Trust, and successfully registered her title. Months later, Miller visited her new property and discovered Lloyd Robinson depositing building materials and beginning construction on a house. When confronted, Robinson claimed he had purchased the land from a third party in 1995. However, he had no written contract, no receipt, and no official registration to prove it. To understand the legal challenge Robinson posed, we have to map their competing claims. The top axis tracks the paper title lineage ending with Miller's 2018 purchase. The bottom axis tracks physical possession. Robinson claimed to occupy this bottom timeline continuously from 1995 to 2019. The timelines physically intersect in late 2018, when Robinson began building his house directly over Miller's newly registered title. Robinson's defense relied on Section 30 of the Limitation of Actions Act. He argued that because he maintained possession for well over 12 years, the previous owner's title was extinguished long before Miller ever bought the lot. If Robinson's timeline was legally valid, the vendor she bought from had no title to pass. Miller would have purchased a property that her seller no longer owned. This exact scenario was addressed in the 1959 Privy Council precedent, Chisholm v. Hall. The ruling established that rights acquired through limitation act as an unrecorded encumbrance on registered land. When a squatter occupies land for 12 years, the bundle of property rights is legally siphoned from the paper owner to the adverse possessor. This transfer happens entirely outside the official registry system, leaving no trace on the certificate of title. The rule from Chisholm is clear. Holding a Torrens title does not immunize a purchaser from a squatter whose rights have already been perfected by the passage of time. This precedent shifts the burden of diligence onto the buyer. A purchaser cannot rely exclusively on a paper registry. They must investigate the physical ground for signs of occupation. In court, Miller established her standing to bring the trespass claim simply by presenting her registered Torrens title. That single document instantly shifted the evidentiary burden. It was now entirely up to Robinson to prove his claim of adverse possession. To do so, Robinson had to satisfy the legal test for possession derived from the case of Powell v. McFarlane. The first pillar of this test is factual possession. A claimant must demonstrate an appropriate, exclusive degree of physical custody and control over the land. The second pillar is animus possidendi, the explicit intention to possess the land to the exclusion of all others, including the true paper owner. Maintaining the 12-year statutory clock requires 3 continuous inputs. Possession must be nec clam, or open, nec v, meaning peaceful, and nec precario, meaning without permission. If any of those 3 elements are interrupted, or simply unproven, the statutory clock resets to 0. Appellate courts keep this evidentiary threshold high to bias the law in favor of the paper owner and prevent the casual acquisition of real estate. To prove his possession, Robinson listed his actions since 1995, occasionally clearing the land, planting trees, erecting a partial wire fence, and hanging a no trespass sign. But cross-examination exposed critical gaps. Robinson frequently lived overseas, and he admitted he had no chattels, fixtures, or buildings on the lot at any point prior to 2019. This triggered the doctrine of equivocal acts, drawing on the precedent set in Farrington v. Bush. The courts have determined that many common actions do not prove an intention to exclude the owner. Even the formal payment of property taxes is legally classified as an equivocal act, not definitive proof of exclusive ownership. The appellate judge classified Robinson's sporadic maintenance and partial fencing as intrinsically ambiguous. They amounted to mere trespass, failing to meet the standard of exclusive factual possession. The evidence that undermined Robinson's timeline was the professional surveyor Miller commissioned in 2017 before finalizing her purchase. The surveyor documented the lot's condition at that time. The boundaries were unfenced, there were no buildings, and there was absolutely no evidence of occupation. Robinson fell into the equivocal act trap. This happens when claimants mistake the intermittent use of land for the legally rigorous, uninterrupted act of exclusive hostility required to strip a title from its registered owner. Because he could not provide proof of continuous control, Robinson's defense failed. The Court of Appeal ruled he failed the test of continuity and exclusivity. Because his actions were equivocal and sporadic, Robinson never legally triggered the 12-year statutory clock under the Limitation of Actions Act. Tydean Miller's status as a bona fide purchaser stands, and her Torrens title remains fully indefeasible. This verdict protects the integrity of the Torrens system. It proves the courts will not allow the Limitation of Actions Act to be used by sporadic squatters to override registered ownership. The Registration of Titles Act and the Limitation of Actions Act exist in a constant state of tension in Jamaican property law, but the burden of proof required to pierce that indefeasibility is monumental. For purchasers, the rule is exact. A registered title is conclusive and safe, provided a physical inquiry of the land reveals no obvious, continuous, and hostile occupation. A squatter must act equivocally and continuously as the sole owner of the land. Anything less is just a trespasser waiting for an eviction notice.